Good evening, everyone. I'm Krista Lundy, the Executive Director at the Meadville Chamber of Commerce, and thank you so much for coming to our third seminar in our seminar series, The Sweetness of Aging, Discussion and Desserts. So desserts are in the back, and discussion is soon to follow here. Very informal. Feel free to ask our speakers questions. I brought in a few experts. Please help me welcome a couple chamber members. We have Attorney Ty Cressman from Cressman and Erdy, and we have Attorney Jeff Youngs from Pepicelli, Youngs and Youngs, and they will be going over the topic this evening is estate planning. So I'm sure everyone is in different stages and has some questions about that for them. So thank you so much for being here for us, gentlemen. We appreciate you taking the time out of your busy schedule on a beautiful evening. So thank you so much. We appreciate it. And I will turn things over to you. So there you go.
Go ahead.
Well, I get to go first because I get to introduce my esteemed co-counsel here, Attorney Jeff Youngs. And Jeff and I have known each other since he was in law school and I was barely a little bit out of law school. Jeff is a graduate of Ohio Northern University College of Law and a graduate of Allegheny College here in Meadville as well. He was born and raised in Cochraton. Jeff has grown up in his family's law practice, doing a variety of tasks prior to entering law with them. He joins Pepicelli, Youngs and Youngs as a third-generation attorney. I think our only third-generation law firm in the city of Meadville, following the footsteps of his grandfather, John V. Pepicelli, who practiced law here in Meadville from 1953 to 1997, as well as his parents, Christopher J. and Lisa Pepicelli Youngs, who have practiced law in Meadville here since 1983. Jeff handles many types of cases, though the bulk of his practice includes estate planning as well as Medicaid planning, real estate, workers' compensation, Social Security disability, as well as guardianships. Jeff is also attorney for the Crawford County Register and Recorder's Office and French Creek Township. And that's why a lot of our questions tonight when we talk about what does your executor do or your executor's responsibilities, you're talking to the boss here, and so you're getting it straight from the horse's mouth. When he's not practicing law, Jeff is often practicing music. He served as choir director at Grace United Methodist Church in Meadville, where he is currently now a pianist. He is a member of the Allegheny College Chorus. He is also involved with Meadville AM Rotary and the Meadville Neighborhood Center. He lives here in Meadville with his wife Chelsea and is quickly becoming a master of home improvement, from which some of us hope to learn. He is also responsible for our first question this evening. Jeff and I came up with what we thought were the most common estate planning questions that we heard, some of the most important that we deal with on a daily basis, and we decided we would handle them back and forth, alternating between the things that we particularly thought were important. And so let me introduce to you tonight's first question, Attorney Jeff Youngs.
Thank you, Ty. And thank you all for coming out. A nice day. It's not something you really want to be inside in a closed building and listen to a bunch of lawyers talk after hours, but certainly we appreciate you coming out. It means a lot to us and certainly to support the community here. And when I was asked to speak here tonight, Ty and I kind of put our heads together and said, you know, how do we compile decades and decades of law into a 6-hour presentation? And see, this is kind of what we came up with. Like Ty said, the couple questions here that we encounter, and our goal here tonight is to educate you folks. And if that's something that we can kind of raise an eyebrow and make you think, oh, well, didn't know I could do that, or didn't know that I couldn't do that, or that it was this way, or that, you know, that's kind of our goal here. So with that said, first question here is, a lot of times we get, what does a will do, and can I be too poor? Can I not have enough stuff for a will? I have nothing, do I need one? Something along those lines. And we say the answer is yes, you need a will, not because we're lawyers and we can help you with that, but a will, you probably know, it says who gets your stuff when you kick the bucket. And that's about all there is to it. Who gets your stuff? There's a lot more, though, kind of digging under the surface to say a will can also name an executor. That's the person who runs your estate, who figures out all your stuff that you have, what bills you have, gets those bills paid, and then ultimately, of course, distributes things per your will, whether that's to your spouse, to your kids, you name it there. You're never too poor for a will because it can do those things, like name the executor. If you have small kids or you know somebody who does, certainly you can name a guardian of those kids. So if something happens to both young parents, the kids might be out there on their own with nobody to take care of them until you go to court and spend a couple grand and several months and get a guardianship, get a judge to say who gets to control those kids. So a will is a place for a parent to do that, and it's really important. The other thing to point out here is if you don't have a will, what happens? Kind of the corollary to that, and that a lot of folks say, well, the state will get my stuff. And that's not entirely true. If you die without a will, the state says who does get your stuff. So there are a specific order of things, and it depends on who's living. Generally, we're saying the spouse gets things first, and then the kids, and then if there are parents still living, and then siblings, and then nieces and nephews, and it goes on down the chain. So it's not like your stuff just sits there for eternity if you die without a will, but the point is that state law controls who gets your stuff. That may not be what you want. Maybe you can't stand your kids. Maybe you can't stand Aunt Bertha. Get a will, get that ironed out so you can have what you want happen when you're not there to tell us that. And the last thing to point out is that just because you die without a will does not mean that your spouse gets everything. There are so many different ways this can play out, but to give you an example, if parents survive you, let's say, then your spouse only gets the first $30,000 from the estate plus half of whatever's left. They don't get everything. Same thing happens if you and your spouse have kids and you die without a will. The other thing, if stepchildren are involved, then the spouse only gets half the estate. It may not be what you had in mind. So the point here, you're never too poor for a will, and a will can do a heck of a lot more than just say who gets what when you kick the bucket. For the next question here, we've got Ty Cressman coming back up, and it's my turn to talk about him. So Ty was born in Titusville, and he attended Penn State University and the Dickinson School of Law. And he's practiced in Meadville since 2008 in the areas of estate planning and elder law. He is partner at Cressman and Erdy, located at 911 Diamond Park, right by the courthouse here in town. He also has an office in Titusville. He became certified to practice before the Board of Veterans' Appeals in 2012, and that involves representing veterans' claims. He became a certified elder law attorney in 2014, and he's also a teacher of continuing legal education, the stuff that teaches lawyers, basically, in the areas of elder law and estate planning. And he's been published in the Stetson University Elder Law Journal and been named a Pennsylvania Rising Star by Super Lawyers magazine, both for last year and this year. And he's the incoming president of our local bar association, and he's a current member of the Crawford County Care Center Ethics Committee. And he currently lives in Meadville with his wife Megan and 2 children, Theo and Bonnie. So for question number 2, would you please welcome Ty Cressman.
Let's see if I can read my own handwriting on these cards. The question number 2, and we face this a lot. If I have a will, do I also need powers of attorney? Now, to some of you, this might sound basic, but the question goes to the distinction between powers of attorney and a will. And maybe it's simplistic, but a functional difference between the two is that a will goes into effect once we die. Powers of attorney are in effect while we are still alive. Powers of attorney essentially allow us to designate persons who could take certain actions on our behalf. And they usually come in 2 forms, a healthcare power of attorney and a financial power of attorney. And they allow us to designate agents who would act in really those respective areas with relation to healthcare as well as relation to finances. Our will, in a lot of ways, is an instruction list for what would happen to our assets after our death, and I think of it as the powers of attorney take place beforehand. Jeff, any additional thoughts or any interesting power of attorney issues that you think are worth raising to the group?
I guess the only thing to add, like Ty said, that the will and powers of attorney is literally a matter of life and death. The will only is good once you kick the bucket, whereas the power of attorney is good while you're still living. And there are 2 different kinds of powers of attorney. So One is for your finances, and that takes effect as soon as you sign it. It used to be that doctors, would have to sign off and say, this person can't write their own checks, can't manage money. Now they're not willing to do that so much. They want to take the risk. So now as soon as you sign that document, it's in effect. On the healthcare side of things, as long as you're talking to doctors and able to communicate somehow, they'll listen to you. So.
That's a great explanation, and that's almost word for word exactly the way way I describe it to our clients. A lot of times you hear the question, well, this power of attorney sounds very broad. I'm giving someone the power to make financial decisions on my behalf with respect to my property. That scares me a little bit. What if they do something what if my agent does something I don't want them to do? Can't we make this contingent on the happening of a future event? For example, when I become incapacitated in some way. And Jeff spoke to exactly the reason why that's not really a practical way to do this. If we make that contingent on a doctor's signing off on incapacity, we may not be able to get that in time. And usually when these documents are needed, specifically a financial power of attorney, they're usually needed right at that moment. A spouse or a parent or a loved one is entering a nursing home, and all of a sudden the agent has a lot of things that need to be done at one time. And so for that reason, we usually don't set up what we'd call springing powers of attorney, where the power only comes into play in a certain circumstance. So on with question 3.
Okay, before we get to question 3, we've touched briefly on powers of attorney and wills, and there are a whole lot of other things that may be on your mind, but just a lot of, like I said, is to educate you folks here. So it's only fair that we see what it is you want to be educated about. So do you have any questions on wills and powers of attorney while we're at this point? And you're certainly more than welcome to ask any questions that you think of. You can write them down. There are some sticky notes or note cards too. We're more than happy to kind of do things on the fly.
I think you go.
Yes, Ross.
I think what I heard Ty say was that there's powers of attorney that is financial and powers of attorney that are health related. If you have one but not the other, is there a default or something like that? Would the courts, whoever has to make the decision say, well, since you set up this one that's financial, we'll go to that same person for the health issue, Is my question making any sense?
It makes a lot of sense. I wish the law were always as logical as you would suggest, which is if I've set up a financial power of attorney, wouldn't it make sense that that same exact person would also be my healthcare surrogate in the absence of a healthcare power of attorney? Pennsylvania, I believe the answer would be no. Pennsylvania has a priority list for healthcare surrogacy that is based on the relationship to the family member, spouse, children, and honestly I haven't had to look at it in a little while, but there are about 6 different parties named, including parents, children, etc. Whether a court would simply say, well, you've named this person in this role, yes, we'll designate that person as your surrogate, is probably unlikely. The hospital is going to look to that surrogacy priority list. I think if you went a different direction, I'll actually let maybe Jeff talk a little bit about guardianship. This is not a bad situation for it. In that situation, Jeff, if a party was applying or petitioning for a guardianship of the person, do you think the court would be likely to look at the power of attorney? Would they not? How would a family resolve that situation, do you think?
Yeah, good question. So the default, if you have somebody for your finances, but you all of a sudden end up in the nursing home, the privacy laws kind of prohibit doctors and hospitals from even talking to a spouse or a child. It depends on where you go. Meadville Medical Center, I haven't heard too many problems with that, but you don't know where you might end up, so kind of why take the chance? But what happens then is we probably do have to go to court and convince a judge that, first of all, you can't take care of yourself medically. So that means a doctor testifying, I'm familiar with this person, they can't take care of their own medical affairs, they need somebody. The second thing you have to show the judge is who's that person going to be? And it can be pretty much anybody as long as the judge thinks they're suitable. So oftentimes it's a family member or a very close friend who's familiar with the person. So just showing them, here's this other power of attorney where they named their son, for example, is certainly going to be in favor of the judge naming the son, but it's all going to be up to what the judge wants to do.
So the message is, really don't do one without the other. You really need to do both of them. Is that what I'm hearing you say?
Yeah, that's what we say. Cover all your bases, just because you don't know what's going to happen. And we'd hate to have that situation where you need your medical treatment, nobody can speak for you, and you may not have the couple months a guardianship takes. Yeah, good question. Other questions on wills and powers of attorney? All right. We mentioned the term executor before, and we get a lot of that stuff. Often somebody passes away, and we've got a child coming in. Well, I've never been executor. What do I have to do? And first of all, we're here to help. A lot of what lawyers do is all that behind-the-scenes stuff of sending out letters, finding out assets, how much are they valued, paying that inheritance tax, paying the bills. A lot of times there's an order that bills have to be paid. You can't just pay the credit card company right off the bat as much as you want to. So a lot of that question is, how do these bills get paid, and where does the money come from to do that? And that's what the executor has to do, and of course follow the will if you've got one, as far as who's getting what. And the lawyers do a lot of that behind-the-scenes kind of things too. Anything to add to that?
Well, Jeff, let's say I have multiple children and I love them all equally. Should I make them all executors? What do you think is wise or unwise in that?
Well, Ty, the way I look at it is, how many cooks do you want in the kitchen? And you can name more than one executor, so they're co-executors, and they have to act together, just as the word co suggests. The problem with that, of course, is, A, do they agree all the time? And a lot of times siblings don't agree. Imagine that. Or maybe they live, one's in Washington, one's in New York City. We can do only so much by email. There's a lot, you have to be on the same page at the same time. So again, while you can do more than one executor, it's often something we kind of advise against because of the practical stuff, practical problems, and things have to be done by a certain time in an estate, and that can lead to some difficulty. Cool, so I'll have Ty come back up for the next question. Take it away, Ty.
Okay. So question number 4. This is a good one and a common one. Does my will control IRAs or life insurance? How do they factor in IRAs, 401ks, and life insurance? And I think when you think of your assets, you could do worse than determining your assets and where they will go based on how you own them. There are really 3 primary ways we can own assets. I can own something solely, I can own it jointly, or I can own an asset that contains a beneficiary designation. And this question really focuses on that last one, assets which contain a beneficiary designation, IRAs, 401ks, annuities, life insurance. This day and age, we're moving more and more towards a non-probate style of world. So you can name transfer on death beneficiaries on many savings accounts. Sometimes they call those ITF accounts or TOD accounts, and you try to keep track of all of these acronyms. But the bottom line is that they allow us to name beneficiaries to all of these assets. As long as you name a person or a trust, those assets that allow you to name a beneficiary designation should not be controlled by your will. What that causes, and Jeff and I probably have a number of horror stories we could share with you. What that forces you to do is give some consideration. This day and age, I do question whether the concept of a simple will still exists. And the reason for that is because we have moved into a somewhat non-probate world with all of these options. Maybe I'm making some of my accounts joint with my child. My will is only going to control assets which I solely own at the time of my death. And so you really want to think about how you're lining up your beneficiaries of those beneficiary designated assets along with the beneficiaries of your will. Maybe you want them to be absolutely consistent. Maybe they're going to be different intentionally, but you almost have to think through asset by asset where these assets are going to pass at the time of my death. When it comes to IRAs and life insurance as well, sometimes those assets passing to your estate could be one of the worst things that can really happen. especially in the case of what we'd call qualified retirement assets, like your IRAs and your 401ks, which are essentially tax-deferred assets. You haven't paid tax on them yet. Leaving them or allowing them to default to your probate estate will result in them having to be liquidated within 5 years and all of the deferred tax having to be paid all at once, as opposed to you could have left them to a person who could have taken those payments from that over a period of time and deferred the payment of that tax over a lengthier period. So no, your will doesn't control, and you should under no circumstance send qualified retirement assets to your estate. Every once in a while we see someone who had a really good will and they liked their will and they said, well, I just made my beneficiary designation my estate. It may have some consequences that are less than ideal. Jeff, any follow-up thoughts, horror stories, or additional thoughts?
A couple horror stories, again, to educate and not put the fear of God in anybody, but the problem with an asset, often retirement plans are one of the things that it's your single biggest asset aside from your house. You've worked how many years to build up what you have in there, and by not having the beneficiaries done right, the tax consequences can be drastic. We've seen a couple cases actually, you're looking at about 30 to 50% of the value of the asset lost to taxes. Because it comes back into the estate, you've got income tax to the estate to pay on that, and then probably inheritance tax when it goes out of the estate on that. So the point is to do the beneficiary designations, because there probably will still be an inheritance tax, but you can save that income tax coming back into the estate. So we all want to save our taxes and pay Uncle Sam as little as possible. That's one way to do it. So,
Jeff, I have a question.
oh, certainly.
You have a couple after that.
Alrighty.
Then can you leave that to all of your children? Or, I mean, can you, instead of putting it in the will, send that over and have more than one beneficiary?
Yeah, absolutely. That's what we recommend, is to have what they call primary and contingent or secondary beneficiaries. So first primary, you die, who's going to get it first? And then we like the backup, the alternate, because if the first person's not there, we still don't want it going back into the estate. And a lot of people will say, to my spouse first, and then to my 3 kids equally, or to whoever survives them. So a lot of times there is particular language that's required. And if you are thinking, well, I've got a retirement plan, I need to check the beneficiaries, make sure you get written confirmation from the IRA plan or from whoever it's with, so you can see it on black and white on the paper who that thing's going to if something happens to you. Another question?
What does will probate and non-probate, what exactly does that mean?
Yeah, do you want to speak to that?
Okay. So it's a really good question. The word probate is something we hear it every day when we think about estate planning. And it's confusing because it's both a noun and a verb. I can probate an estate, which is an action, which really means I am taking, well, actually, I could be corrected on this, but generally speaking means I'm taking the will of a deceased person to the courthouse in order to be sworn in as an executor. I am initiating the process of estate administration. Probate also refers as a noun to the process itself, the marshaling, gathering up of the assets, paying creditors, paying taxes, distributing to the beneficiaries. That entire process is sometimes the probate process. A good way to think about it is the probate process is only going to apply to probate assets. Generally speaking, and I say generally, that's going to mean solely owned assets. It gets back to that solely, jointly, beneficiary designated. Those are going to be your classic probate assets. Usually if you have a husband and wife or a spouses, one spouse passes away, now the other spouse owns them solely. So things which are jointly owned assets generally over time may become solely owned probate assets. We'll have a couple of questions, I think, later on about really to what extent is there value to avoiding probate. Sometimes it's not all it's cracked up to be, to give you a preview, I think, of where we're going with that.
Yeah. Sounds good. Other questions at this point? Okay. The next question we have is, can I do my own will? or I bought this form online. Is it good? And the answer is I don't recommend it, and I don't know until I see it. So lawyers are happy to at least look at what you might have done yourself. And we've seen some things, LegalZoom. And I used to carry around a zipper binder with me. We had somebody who had a binder about as big as this piece of paper and about 4 inches thick, had a nice little zipper on it, a nice little plaque that said LegalZoom and the lady's name on it, and it had a will and a trust and some powers of attorney and all the kinds of stuff we talked about, and nothing was signed. There were no instructions in it to sign it. There were no instructions to transfer property into the trust, no nothing. And I asked the son, after Mom had died, you know, how did this come about? And she said, well, she saw it online and ordered it and paid $3,000 for it. And then it was my job to have that tough conversation to say, it means nothing now. So that's where, you know, state law comes into play, like we talked about. So the takeaway, of course, is don't try to do your own will, and if you have, lawyers are happy to at least advise, and the other things we talked about a will can do, whether it's the executor or the guardian for your kids, or figure out if this best fits your needs. Questions on that? All right.
Jeff, I have a follow-up question, just because we raised it a little bit with the not signing. Can you talk a little bit to the execution requirements, generally speaking, of a will? Maybe I kind of made one up myself at my house, but I had a notary sign it. Is that what's required? What is required of a valid will in the state of Pennsylvania?
Yeah, in fact, that will you made at your house, you should bring to me, and I'll be glad to make sure it's properly done. The wills need to be signed a particular way. They need to be signed at the end, certainly. So we have folks who go back later and, you know, cross something out and sign their name next to what they crossed out up on the first page. Sometimes that can nullify everything after that signature. So you need it signed, and then 2 witnesses, and that's about all the bare bones requires is just that it be signed. The point we're saying to go beyond that, you have 2 witnesses, you get a notary. There are a couple other places each of those people have to sign, so that the will is what we call self-proving, and we need that. When you go to the courthouse, they'll look for it, the self-proving language, they call it. It basically says, this person signed their will, and we were the 2 witnesses, and we saw him do it, and he told us to do it, and that was it. If you don't have that, you have to go track down both those witnesses, and they have to sign something saying, yes, this is my witness name, and I saw this person sign. Sometimes those people are dead. Sometimes they just can't be reached and aren't responsive. So it takes a lot of work behind the scenes just to get the will to the courthouse. So again, the point here, just don't try to do your own will, or at least get the advice of a competent lawyer here to look it over, make sure it does what you want, and that it's properly done. Anything else to add on that? Or questions? Yes?
Jeff, so what happens if one of your witnesses or both your witnesses leave the area, die, you can't find them? You need another witness? Do you need to go back to your attorney and have...
That's the importance of that self-proving language at the end of the will. That way you don't need those 2 witnesses to come back in and say, this is who I am and this is what I saw. But if you can't get that, there is another way to do it, to have somebody, 2 people, come in and say, I'm familiar with John Doe's signature and with his handwriting, and this signature on this will is what I believe to be his signature. So there are ways to do it. It's just a little bit more administrative work and more that you have to pay your lawyer. So save your money and get it done right. Other questions on that? All right, take it away.
Next question. So question number 6. Should I make my bank account joint with a child? I'm sure Jeff will have some thoughts on this too. This is a pretty common question. And I guess the answer, and this could probably be the answer to most of these questions, is, well, it depends. But generally, our favorite answer. The first question you usually have to address if you're thinking about making a bank account, or really any asset, joint with a child or joint with another person, is what am I trying to accomplish by this action? That's always, if you're taking any estate planning action, that's the best way to make sure you're doing the right thing, is getting to the why of a certain action. So why would I make a bank account joint with a child? Some people would say, well, I want to make sure my child can have access. If I were to go into the nursing home, I want to make sure my child can write checks. Well, as we talked about earlier, a power of attorney is going to assure the access issue to a bank account, and it's going to do so at a lot less exposure, generally speaking. Once I make an account truly joint with a child, that person can go in, write checks, take out money, do anything that I myself could do. So it just, again, if that is the only reason you're making an account joint, probably a power of attorney is better to get the job done. Sometimes the reason is I want to save on taxes. I want to make my bank account joint so we save some taxes. Now there is some validity to that reasoning. Pennsylvania inheritance tax on assets, let's say net assets passing to a child, is 4.5%. If I make an asset joint with a child, I can potentially cut down on that tax by about half, so long as my death occurs more than 1 year after the date that I've made that joint. There's a little bit of a look back, 1 year look back for Pennsylvania inheritance tax purposes. So there is some validity to taking that action for that reason. I will tell you, and probably Jeff agrees, many of the times we're dealing with this question, a 4.5% tax on half of the value of that account maybe does not justify the exposure of making an asset joint with a child. That's something you have to individually consider. It's a laudable thing to try and save taxes. However, you want to be thoughtful about that other person that you're making it, or with whom you're making the account joint. Sometimes we get the explanation, I'm desire to make the bank account joint to protect it from the nursing home. That's an easy one. Making a bank account joint with a child does in no way protect it from any sort of Medicaid. It's considered to be yours because you have full access to the funds in that joint account. What can happen is that, or especially in the Medicaid context, you might make a bank account joint with a child, and then that child maybe writes a check or draws some money out of that account. Then a gift is taken place. And again, as we'll talk about, there's a 5-year look-back rule, and there's some other consequences to that. So I guess my advice for people who get this question is give some consideration to what you are trying to achieve by making that account joint. You may be able to find a more direct and maybe a more safer way to accomplish that same goal. Any additional thoughts or horror stories on joint accounts?
No horror stories, although they do exist. I just haven't been around long enough to have dealt with one. But I can tell you, like we tell everybody, know the risks. You can do this kind of thing, certainly. There are advantages, but know the risks. And the big risks should be take a look at the person you want to name joint. So, well, a kid is a common example. What's the kid's financial status like? Are they responsible? Are they going to take your money and run? Because the account is basically half theirs and it's half yours. They could take all the money out and go off to Europe on a cruise or go do something with it that you wouldn't like, and then you've got a whole mess to deal with there. The other risk is to look at their profession or look at their finances. If they're going to get sued by creditors, or likely to, maybe they're in a high-risk profession like a lawyer or something like that. If they get sued, then they've got assets that include this bank account you've now put them on. You could lose the money to somebody who your kid owes money to as well. So again, just know the risks, but it can be done.
And one last point, just for a minute, I know there's a question there on joint ownership. If you make it joint, if you are going to make it joint for whatever reason, make sure it's actually joint. Sometimes we have people come in and they say, well, my son's name is on the account. That could mean a variety of things. It could mean the child is on as a power of attorney or an authorized signer. It doesn't necessarily guarantee joint ownership. And so if you really want to make something joint for a reason and you've talked it over with your estate planning attorney, ask the bank, make sure the child's name is on the signature card as a joint owner. Kind of press the bankers on that question just to make sure you're on the same page. Sometimes we see people under the misapprehension something is joint and it's actually not. But a couple of you had questions and I kept talking, so yes.
I was bank manager at Penn Bank on North Street for a good many years back in the 80s and the early 90s, and one of the things that we always told people if they wanted to make it joint with their children is if your child passes away first, then you have to pay inheritance tax on the half that they supposedly own. Mm-hmm. Is that correct?
Yes.
Now, correct.
Yes, and it's a good point, and I thought about mentioning that and didn't. One of the risks, and again, there are risks, and then there are risks, but one of the risks for certain is that if your child predeceases you, you're going to be paying inheritance tax on half of the value of that account as well, which really can be not what you anticipated taking place.
That did happen at North Street when I was manager. A mother had the son, and it was like they and like the son and the mother and the son died. He had cancer and he died. And the mother came in screaming at me because she had to pay inheritance tax. And when the account was opened, of course, I was not there. A manager, the person before me, obviously didn't tell them this.
That's an unpleasant surprise.
So I just wanted to clarify that if that was still true.
Still true.
Good.
Question number 7.
Well, we'll kind of shift gears a little bit, enough about powers of attorney and wills and all that crap, and move on to trusts. There are a lot of different kinds of trusts. You've got revocable trust, you've got irrevocable trust, you've got special needs trusts, you've got testamentary trusts in the will, and so on. We can't talk about all that today, or you'd never get home and get to bed. So we'd just like to focus the next question on a revocable trust, what that is, and do you really need one? So the revocable trust, a trust is something that you set up and you name somebody else to manage it. So you maybe want to put your house in trust and have your kid manage it, so when you and your spouse pass away, things kind of stay in the family. Maybe it's a family farm or an heirloom property or something like that. That's certainly one reason to do it. If you've got property in several states, maybe a retirement home in Texas or Florida or something, maybe that's a time to put your house here in the trust and your house in the other states in trust. The trust keeps on owning it beyond your death. It's not a bulletproof kind of thing, because Uncle Sam still knocks on the door and says, pay me inheritance tax on the value of what's passing. So you still have inheritance tax issues in each state that you have property in. We can't get away from that. There are also some ways where if you have a husband and wife, let's say, maybe one is in bad physical health and the other is in bad mental health, neither one can really completely manage their own affairs, so you just kind of send everything over to the trust. That's one way to do it, but my response to that from experience is to save your money, get a good power of attorney and somebody you trust to act for you. Like we talked about earlier, you don't need the trust for that. There are a couple other cases. If there's a child that has special needs of some kind, can't quite manage their own affairs, maybe you want to set up some money in trust for them. That certainly is another way to do it. But other than that, my general response to folks is that trusts are oversold and not accomplishing what people think they do. A lot of folks see them as something that, well, I can keep everything secret, keep everything out of probate, and it'll save me money. Well, certainly there's some cost for the lawyer to draft the trust in the beginning. You still have inheritance tax issues, and under the Uniform Trust Act, by the time you kick the bucket, chances are that trust has to be done just like any other regular will and like probate, and there's the same process to go through, even though it's a trust. So keep in mind that there are very limited circumstances, in my experience, that we'd actually recommend you spend the money on something like this, but there are some benefit circumstances too. Anything to add to that?
Good estate planning lawyers, like you're seeing here, love to beat up on revocable trusts because they are, as you heard, oversold, and oftentimes they are sold at seminars at a hotel or the Holiday Inn where you get a free lunch and you hear about all the good things a revocable living trust can do, and then they sell you a bill of goods. And it really, in the state of Pennsylvania, it may be true in other states, there may be some benefit there. In Pennsylvania, there's really not. We're in agreement there.
Two lawyers actually agree on stuff, would you imagine that?
Okay. Question number 8. Well, we're getting into the meaty stuff here. If I go into the nursing home, does the state or does the nursing home get my house? And so the short answer is no, not automatically. Medicaid is, when we talk about nursing home care, it's a complex scenario, and typically we're talking about skilled nursing home care. There is a Medicaid program that helps pay for that. The Medicaid program is a means-tested program. Your assets have to fall below a certain level before you qualify for Medicaid. Whether you're married or whether you're single, the thresholds are a little bit different. However, you have to be fairly low. Your house is an exempt asset. It's almost never, or at least very rarely, your primary residence is not going to be counted towards your asset limit. And so if you were to make a study of how the Medicaid program works, I would recommend you divide it up in your mind in terms of 3 separate portions. The first one would be eligibility, the second one would be gifting rules, and the third one would be estate recovery. That's a pretty organized way to approach Medicaid. So from an eligibility standpoint, that's the important one. When we have someone going to a nursing home, we want to qualify for Medicaid. The home is an exempt asset, so that neither the nursing home nor the state of Pennsylvania are going to be going after your home. If it's valuable enough, there are some home equity limits. Generally speaking, they're not going to be applicable so long as you have a spouse in the home, but that is something to be aware of. But generally speaking, in Crawford County, the house is going to be exempt. Where they get you from a Medicaid standpoint is the estate recovery phase of that description. If you are a single person who is qualified for Medicaid while owning a house, and then you pass away owning the house, your state or your estate owes a bill to the Commonwealth of Pennsylvania in the amount of medical assistance you've received during your lifetime. And oftentimes, your estate will have to sell the house to pay off that bill. That's how estate recovery works. So no, not immediately does the nursing home or Pennsylvania get your house. As a practical matter, estate recovery could very well get your house. And we could spend a lot of time talking about the estate recovery rules. I don't want to bore you with all of them, but I will say that, again, your knee-jerk reaction to you or a loved one going into the nursing home doesn't need to be, oh my gosh, I'm afraid we're going to lose our house. It doesn't. It's just not the way it works. Any additional thoughts on the...
I think you covered that one.
Okay.
I have a question.
Sure.
Where you gift your house to a child?
Gifting rules. And let me check for a moment to see if we are... Oh, you know what? We're actually going to be talking about exactly that question right up next. So, oh, yes.
I do have a question. How does that affect the spouse as far as the paying back of the Medicaid?
So it's a really good question. An estate recovery in Pennsylvania is what we'd call a very narrow estate recovery. It applies only to probate or probatable assets. And so if you have a spouse, and say spouse number 1 goes into the nursing home, spouse at home is still in the community, there is very rarely a situation where estate recovery, really unless someone, there's very rarely a situation where estate recovery is going to apply, because upon the eligibility of spouse number 1 for Medicaid, usually the house would be transferred into the name of the spouse in the community, or even through joint ownership. Generally speaking, the institutionalized spouse will predecease the spouse in the community, and so it's going to pass there automatically. Every once in a while you run into a situation where the house has been left joint between them, and then the community spouse passes away. Then the house passes back into the name of the institutionalized spouse. But generally speaking, because in Pennsylvania right now we have a very narrow estate recovery, it's pretty easy to avoid estate recovery of the house so long as you're thoughtful about transferring. That's always subject to change. I always talk to clients about estate recovery because unlike a lot of Medicaid, Medicaid is a federal and state joint cooperative program, and so it's very hard to change some of those underlying eligibility rules for Medicaid because it requires an act of U.S. Congress really to do so. Estate recovery is left up to the states to figure out how they're going to do it, and so we're always subject to seeing our state's estate recovery change. And so the best thing you can do as a Pennsylvania voter is keep a little bit of an eye on that and hope that it doesn't change. States like Wisconsin, for example, have a broad estate recovery. They can go after everything from jointly owned assets to life estates to all those other things that we use to avoid estate recovery.
So other than your house, if you have to go on Medicaid, they'll take your bank accounts and stuff, right?
So the
So
way
you're left with Social Security.
that's typically it. Because Medicaid is a means-tested program and your assets have to fall below a certain level, typically speaking, the only assets that are really left behind, especially for a single person, in that single person example, are going to be exempt assets like a house, a car, and really that's going to be about the only recoverable options out there. Everything else has already been fairly reduced. You qualify for Medicaid, and generally speaking, all of your income is going to go to the nursing home as part of your patient pay liability. And so but that's okay because your needs are generally being met by the Medicaid program at this point. When you have a spouse, the situation becomes a little bit more complex because under Pennsylvania law, your spouse is able to keep some amount of assets. And so oftentimes that community spouse or the spouse in the community will have retained some assets in his or her name.
Plus their Social Security.
Any income of the spouse who is still at home is his or hers without respect to Medicaid. And so that's like
It's going, if he's in the nursing home, his is going away.
his is going to a certain extent. There are certain spousal protection provisions that can allow for the allocation of an institutionalized spouse's income over to the community spouse. So I don't want to be. Okay. Yeah, I don't want to cut into. We have some spousal protection questions actually coming up.
Yeah. Just to put it in maybe a different light and put some numbers to things, we're talking about Medicaid and the planning, for the generic term. About the best way I can explain that is to ask you to think about what you have, and whether that's the whole gamut. You know, your life insurance, all your cars, your jewelry, your furs, your house, you name it, you've got it. Think about what that might be worth. And then picture a time where you might go into a nursing home and writing a check out to Crawford County Care Center for about 10 grand a month. And how quickly everything you've spent decades and decades working for, how quickly that's going to deplete what's in that bank account. And the issue we run into for Medicaid eligibility that Ty has mentioned here, generally speaking, depending on your income, think of everything you have and then think of writing that check out to the nursing home every single month until you get down to about $2,000, or in some cases, $8,000 bucks. But think about that. How much of your money would you have to spend to get down to that level? Because that's when you qualify for Medicaid. That's when the state comes in and says, all right, you're poor enough now, pretty much. We'll pick up the tab and pay for your nursing home care. So now you've got care you need, and you need it to live, and you've got nothing to pay for it. The government's picking up your tab, and now you've got nothing to give to your kids. Because the state is likely to come back later and say, you're gone now, what do you have so we can get paid back all that, or whatever you have, to pay us back for what we paid for you. So the idea here is, what can lawyers do legally, and kind of, hate to use the word loophole, but there are things that are not illegal that we can do to say, look at that pot of money you've got now, how can we save that, how can we preserve it, keep it in the family, keep it so family and relatives can benefit from everything we've worked for. And you still go in the nursing home, the state picks up your tab, you and your family benefit from a lot of your assets. And that's kind of the beauty of Medicaid planning when it's done properly. So just a little bit of cold hard truth context there. You don't want to be writing that check out every month till you get down to $2 grand. Anything to add to that?
That's good.
If
Okay.
you own a corporation, will that money be taken, even though it's in a different name?
Funny you should ask, like you might own decorating den interiors or something. That would just depend on the corporate bylaws and who owns what. There's a lot of stuff to come to mind when a corporation's involved. So I think that's a little bit beyond what we're talking here, unless you've got some
Well, it's only us two.
targeted answer. So
One of the most helpful protections that spouses have is the fact that transfers, and we'll talk about transfers that are either penalized or exempt here in a few minutes, but transfers between spouses are exempt. There's no penalty for those. And so as long as, I don't want to be overly simplistic about it, but as long as you have a spouse who is still in the community, especially if it's a co-owner of a business, the ability to make those transfers is much easier. Generally speaking, a business is an exempt asset so long as it's income producing, especially when you have both spouses alive. If If you had say a spousal business, you probably could make a transfer that from spouse to spouse without too much difficulty.
And kind of a good segue there, Ty. Generally speaking, transferring things to spouses when you're looking at that Medicaid planning, generally there aren't any issues there. We want spouses to get along and the marriage to function as a unit, of course, so transferring husband to wife and wife to husband generally won't be any issues for Medicaid. And of course, Medicaid, the other thing to add to what I said is you can't just give away all your stuff, go into a nursing home and expect the government to pick up your tab. I wish it were that simple, but some of the things we look at are, what can we do? And Medicaid has that 5-year look-back period. So if you apply tomorrow morning over a cup of coffee, if you fill out your Medicaid application, the state looks back 5 years and says, have you given away any of your stuff for less than fair consideration? So common example, you transfer your house to your kid for $1 and need nursing home care, and within 5 years of doing that, the state looks back and says, well, I see your house was worth $200,000, you only got $1 for it. Then what that means is there's a formula, and the end result is how long you are ineligible for Medicaid. So that creates a problem. You've given away your house, you don't have it now, and how do you pay for that kind of care when you don't have the money to do it? So just kind of some background there. There is that 5-year look-back period that probably most of you have heard about for giving away things and not getting the right amount of money for them. Some other question here that Ty has alluded to is kind of what happens if the spouse goes into the nursing home? And our advice would be to call your elder law attorney. There's a lot of stuff that happens when a spouse goes into the nursing home. The spousal impoverishment, for the fancy words, that part of the law was designed so that the spouse who's at home is not dirt poor. We don't want that. But the law is not designed to allow your spouse to keep having 3 vacation homes up in Cape Cod and 12 Mercedes-Benz and all the lifestyle that they were used to before you went into the nursing home. And husbands, I'll pick on you, pick on myself. Usually it is the guy who needs the nursing home care who ends up facing this kind of situation first. There are ways to plan, and that's why I say call the lawyer when something like this happens. We like to plan outside of the 5 years. We don't have the crystal ball, but that way if you transfer the house to the kid for $1 today and 10 years from now you need nursing home care, so what? The house isn't an issue, the car isn't an issue, whatever you did outside the 5 years doesn't matter. But the point here is when you look at nursing home care, a lot of folks do wait till the last minute and there's still light at the end of the tunnel. Some just examples, you've got husband going into the nursing home, maybe you transfer everything out of husband's name into the wife's name who's going to stay at home. That would be one way to get things out of husband's name to get him down to that $2,000 level. You can also, it's a time to change the wills. Maybe you take so that the assets of the spouse who's at home can pass on to the kids instead of saying all to my husband, because that can create an issue where they have too much now and they're kicked off of Medicaid. You can also transfer property to a blind or disabled child, and there are specific criteria you have to meet to be blind or disabled there. The other common way to do it is transfer your primary residence to a child under 21, which I've never had anybody do that. When I tell them you had to be 21 or under 21, what kid could do that? I couldn't have when I was 20. Or if you've got a live-in child who's giving you care and keeping you out of the nursing home, you can transfer the house to them and other things, and you don't have the same kind of 5-year look-back issues you'd have otherwise. The other way, and there's some meat to this, we don't think we have time to cover all tonight, but a Medicaid annuity, which is kind of a brilliant little device. So husband goes into a nursing home, they've got $400,000 in total assets, husband and wife. And yes, Medicaid counts everything that both people have, husband and wife, even if just husband is going into the nursing home. So husband's in nursing home, and under the law, to give you an example, the couple can only keep about $240,000 of what they have in order to qualify the husband for Medicaid. So some quick math, that means that you have to spend about $160,000. And there are a couple ways to do that, one of which is by spending $10,000 a month, writing the check out to the Crawford County Care Center, and you'd use up $160,000 in less than a year and a half. That's one way. The other way, one example, is to consult some brilliant lawyer who says use a Medicaid annuity. So the wife who's at home can spend $160,000, go out and buy an annuity that meets certain requirements, So she gets a stream of income while she's living at home, and she still gets Social Security, and she can maintain perhaps a comfortable lifestyle. So if the wife lives long enough so that the annuity pays out over the term it's supposed to, then the annuity won't pay anything back to the state for all the care that husband got. So wifey can get all this benefit and not have given 160 grand to the nursing home. So then the other thing, if wifey dies before the annuity's done, then the state gets repaid for the amount of money they spent on the husband's nursing home care. But the rest of the annuity, if there's anything left, can then pass on to kids. So again, you're still saving a good bit in your assets and not writing the check every month for nursing home care, but doing that Medicaid annuity. So I know I covered a lot of stuff there, but certainly a lot of stuff can be done even if somebody's looking at nursing home care tomorrow. Something else to add to that?
I would say that, annuities and Medicaid eligibility are a complex subject. Both Jeff and I have left materials out there that include our websites. Those websites can be a nice place to start to gather some information. Part of the nice part about tonight's get-together is we get to be here. We don't have to worry about the cost of a lawyer or sometimes the uncomfortability of being around a lawyer. But when you're doing research for yourself on this topic, make sure you're sticking to sort of Pennsylvania-specific legal sites. Pennsylvania or Medicaid law is going to differ significantly state to state, and so even in some of the wonderful things we can do with annuities here in Pennsylvania cannot be done over in Ohio, which sometimes causes us a little bit of trouble. We have residents who live in Pennsylvania and they are going into a nursing home in Andover or somewhere nearby. We don't have the same options necessarily. Also, when you're trying to keep track of this, going back to something you heard earlier, it can be easy to get lost in the weeds thinking about this. Try to break up Medicaid and long-term care according to those portions of the Medicaid program. Something is going to be related to eligibility, something related to gifting, something related to estate recovery, because you'll be worrying about all of those at different times. Jeff talked a lot about gifting exceptions, transfers which are not going to trigger a penalty. Those are some helpful ways to, I guess, break up the topic in your mind. It's a tough one, and when we talk about estate planning and elder law, I think it's come to the point where even our fairly straightforward estate planning discussions tend to have some elder law bent to them. There just doesn't seem to be a whole lot that we're talking about that doesn't get us talking at least somewhat about long-term care. Any questions, or are we were being waved at from the background to make sure we kept you in time, but maybe we have time for one more question, or maybe
Any more
maybe we.
questions from anybody? You can certainly see them afterwards as well. Big round of applause.